Oh, yes, yes, yes. They have attachment number 2, the Violence Against Women's Act, 18 U.S. Code 2265. Now, when you really read this, the full faith and credit given to protection orders, yes. Full faith and credit, any protection order issued that is consistent with subsection of this section by the court of one state, Indian tribe or territory, yes. Guam being a territory, yes. The issuing state, Indian tribe, or territory shall be accorded full faith and credit by the court of another state, Indian tribe, or territory. Enforcing state, Indian tribe, or territory, and enforced by the court and law enforcement personnel of the other state, Indian tribal government, or territory, as if it were the order of the enforcing state or tribe. Now, what's known as a protection order? Yes, a protection order issued by a state, tribal, or territorial court is consistent with this subsection if such court has jurisdiction over the parties and matter under the law of such state, Indian tribe, or territory. Yes. And this is really important. Reasonable notice and opportunity to be heard is given to the person against whom the order is sought, sufficient to protect that person's right to due process. Oh, now I'm going to read this again because it seems that the state of Washington doesn't understand reasonable notice and an opportunity to be heard is given to the person against whom the order is sought, sufficient to protect the person's right to due process. In the case of ex parte orders, notice and opportunity to be heard must be provided within the time required by state, tribal, or territorial law. And in any event within a reasonable time after the order is issued, sufficient to protect the respondent's due process rights. Oh. Now, these due process rights that you say that you did protect, as upset as you are today, you have no idea how angry I am. And when you issue a protection order in the state of Washington, when I know my due process rights were protected when I was arrested on Guam, yes. And I had agreed to do the diversion, the 7 hours of parenting classes, yes. And you had absolutely no jurisdiction. The serving me of the actual protection order that was issued in 2011 does violate the requirements of the VAWA. Now, I've explained this to you, yes, but it also violates Washington State's Foreign Protection Order Act. Now, you're going to get to go to prison, and I'm going to sue you for everything that you own. Oh. Now, if you had protected my rights, you had served me within a required amount of time. Let's say on or before the next judicial day, you had attempted service on Guam. Yes. And I could have gotten my passport. I could have traveled back to Washington State. Then I could have motioned the court to have it removed, but you didn't have jurisdiction of law. Now, you made up some bullshit excuse. Now, let's talk about the cross or counter petition. Yes. A protection order issued by a state, tribal, or territorial court against one who has petitioned, filed a claim or a complaint, or otherwise filed a written pleading or for protection against by a spouse or intimate partner is not entitled to the full faith and credit if no cross or counter petition, complaint, or other written pleading was filed seeking such protection order. As if I hadn't filed one against my wife in Washington State while I was in jail on Guam. Now, this cross or counter petition that you've obstructed for the last 7 years and 4 months, where I told you, well, I didn't get notice of the fucking court hearing.